Good morning, everyone, and welcome to the first in our webinar series where we look at common development pitfalls and obstacles to developing land. Right, let's get going. So we've got a short and sharp session this morning, only 30 minutes, so it'd be good to crack through what we've got on the agenda. My name is Patrick Weatherall. I lead our developer sector and our real estate disputes team. I'm delighted to be joined by my colleagues, David Crockford. David's in Southampton.
Hi, everyone.
David says good morning. And Rachel, who's obviously joining me in Bristol. We're trying to not just be old-fashioned sort of webinar, a bit more in person, so you can actually see us in an office for a change. So in the next half an hour, the three of us will be discussing our top tips and strategies for obtaining vacant possession of open development land. We don't have time to cover everything. We're not going to sit and try and lecture on the law. What we want to do instead is look at what we see in practice as being the real hot topics and suggest some strategies for overcoming them. So we have mocked up an imaginary development site, which hopefully you can now see. There we are. We'll call it Dillington Fields. It's completely made up. As you can see, the land is largely open. We've got to the west an established row of residential housing. To the north, we've got a commercial unit. To the south, that triangle represents a telecoms mast. And you can also see some footpaths running across the land. Now, we're going to focus on three main topics, and hopefully we'll cover some others if time allows. Those three main topics are town village greens, which I'm going to talk about in a moment. David will then look at the potential rights to light issues in respect of that strip of houses to the west. And Rachel will discuss the telecoms mast and the steps required to secure its removal. And then if we have time, we'll look at things such as rights of way, business tenancies, grazing licenses, FBTs. Please do feel free to ask questions. However, I don't think we're going to have time to actually address them within this half an hour, but pop them in the chat or contact us separately and we will come back to you. So here is our development site. Green Development Co. acquired the land in 2007 and have had long-standing plans to develop it, but frankly have done very little to maintain the land. Recent inspections just been carried out, and it can be seen that the site is largely open with gaps in the fencing, and people have been forcing entry onto the land. There are well-established footpaths that you can see, which have been used by walkers for dogs and for other recreational pursuits. The row of houses to the west, called Ilminster Gardens, there's no fencing along that boundary, and some of the residents have taken advantage of this by storing bins and putting up rope swings. There are a couple of signs on the land that say private keep out. They were put up by the previous owner of the land. So, what do these observations raise? They raise the potential for this site to be designated as a town or village green, TVG. They also raise the possibility that private rights of way have been acquired, or indeed a public right of way, and possibly some of the residents might have acquired land by adverse possession. We've also clearly got, in terms of the wider development scheme, the challenges around the occupational tenant to the north, the business tenancy, and indeed the mast, which needs to be removed. So turning to TVGs, TVG status can be conferred, frankly, on any land. It doesn't have to look like a traditional village green. And once land has been designated as a TVG, if you interfere with it, it's a criminal offence. So designation can restrict or prevent development entirely. Moreover, any application takes a long time to be considered, roughly 1 to 2 years. And so even if you have a strong case for resisting TVG status, the very fact of the application is a real nuisance. So what we're thinking about here is not only the merits of a TVG claim, but a strategy for avoiding the application altogether. Now, the fundamental basis of a claim for TVG status is as follows. You need to show, the locals need to show that they've used the land for lawful sports and pastimes for 20 years without secrecy, without force, and without permission. And a significant number of people who come from the locality or any neighbourhood within the locality have done so. And the application must be made within 12 months of the land ceasing to be used as a TVG for TVG activities. Now, in our scenario here at Dillington Fields, we think the land has been used for more than 20 years already, and that is crucial when it comes to thinking about our strategy. On the face of it, the inhabitants, the local residents of Ilminster Gardens, have a reasonable claim for a TVG to be made out, notwithstanding the fact that they may, on occasions, have broken through fences and may well have ignored or chosen to ignore the one or two signs that are up there. So, in a nutshell, there is a risk, and it could be a finely balanced exercise for a local authority to decide. So how do we go about avoiding an application being made at this stage? There are two ways. One, you prevent the land from being used as a TVG for a period of 1 year without an application being made. Or secondly, you instigate what's called a trigger event. These trigger events are set out in something called the Growth and Infrastructure Act 2013. So one option, and you see this quite a lot in practice, is clients and agents are quite eager to put more signs up and put fencing in place. Great, that will start time running. Of course, the natural consequence of that is that the local inhabitants get wind of this and think, right, well, how can we protect our land? We need to make an application within that year. So you run a real risk by doing this. So the main probable alternative is to instead look at the trigger events. There are a number of trigger events, but the one that's most commonly used is where you've got an application for planning permission published. So if Dillington Fields was in the local plan, that would also be a trigger event, but in this scenario, it's not. So we're advising the client, what do they do at this stage? And the tactical advice is to think very carefully about now making an application for planning permission. And it's not an application for planning permission that has great fanfare around it, because if you have the normal pre-consultation, that in itself could flush out an application. The great advantage then of the trigger event is that once you get that application in, so long as the planning permission is subsequently then granted, there's an essential freeze on TVG applications being made. So that in a nutshell is the strategy for this sort of scenario, and that can impact on the other areas of advice that we will turn to in due course. Anyway, that's TVGs. So let's have a look at the row of houses to the west. So if there is a development at height on Dillington Fields, there is always in these cases a real risk of a rights to light claim. David, over to you.
Thanks, Patrick. Yeah, it should be no coincidence that in our entirely made up example, exactly the most common experience we get with rights of light appears. And the most common experience we have when dealing with rights of light issues for clients is a row of residential housing bordering onto the site. That row of residential housing has been in existence since the 1950s, the 1960s or longer. The key thing that will be the key issue to deal with is the need to protect the development from being stopped at any point by a right of light injunction claim from one of those neighbouring owners. And the question, sort of the first question that we'll need to answer in that situation is, do the parties being the properties on the west side of Ilminster Gardens as they appear on this site, have express or implied rights of light? So the first test or the first approach that should be taken is to confirm whether there are or are not express rights of light. The instinctive thing to do is to review your title. So in this case, you would review the Dillington Fields title, but you should also be checking the properties on the west side of Ilminster Garden that are bordering the site. Because while the burden may not be registered over Dillington Fields, the benefit may well be registered over those properties. So that should be the first thing you should do in these situations. At this point, the neighbouring owners shouldn't be approached, but the land registry title should be checked. If there are no express rights of light, or if there are no express rights of light, then the concern is going to be implied rights over Dillington Fields. We see several arguments made as to why a party has implied rights, but by far the most common is that the right of light has been acquired by way of prescription. The test is if the light has been enjoyed without interruption for a period of at least 20 years, starting from the date on which a property on the west side of Ilminster Gardens raises a challenge to the issue. couple of things that are specific to rights of light that are worth just noting. I won't go through them in too great detail, but it needs to be provided that no written consent has been given. Again, for a prescriptive right, as Patrick's mentioned in respect of TVGs already, the right needs to have been exercised without force, without secrecy, and without permission. He's sort of dealt with that, but the thing that's worth remembering on this is, unlike other prescriptive rights, only a written consent would defeat a right of light claim. So information would need to have been taken from the owner of Dillington Fields at the time as to whether anything had been given. So that's, getting in there early and understanding the information that's coming from the person you're buying from or taking under option is pretty important. The biggest risk here is the grant of an injunction rather than the award of damages. Award of damages is obviously significant, but it's not going to compare to the cost of redesign or cutback of a building at height. Injunctions are a very real risk where rights of light, be they express or implied, are identified or you're concerned about them. There have been recent cases, and it's worth being aware there have been recent cases where injunctions have been granted requiring a substantial cutback to the development. In those cases, and this could be a topic all by itself, but there have been, the developer has been given the option to pay huge profit-based damages sums in lieu of the injunction, but it's not the same as the damages sum that you would see generally at an early stage. Crucial to get out ahead of this issue and avoid potential ransoms down the line. So the steps to take, if you're developing at height, or if you're increasing the size of a building. So in this situation, Dillington Fields doesn't have any buildings on it, but it would be fairly common to see buildings of a decent height there already. But you need to remember that if you are taking an existing building and increasing the height, exactly the same things apply as I'm talking about at the moment. If you're doing either of those things, then a rights of light surveyor should be appointed at an early stage. They will assess on the basis of plans and drawings whether there are likely to be any prescriptive rights, and if so, the cost of releasing those. They will give you a sum that the residential owner may be entitled to. There will be a book value, so that will be the actual financial loss that the owners on the west side here of Ilminster Gardens would suffer. But the number that they will give you will be increased 3 to 5 times to take into account the injunction risk, the commercial strength effectively of the owners on the west side of Ilminster Gardens. So, and that's what's referred to as the enhanced book value. We have seen in the litigation team numbers as high as 7 to 10 times the book value, where something is particularly sensitive, where something is more advanced, where there is an outstanding factor, but the increasing factor will go up. So again, crucial to get in front of it as soon as possible. So if there are rights of light, number one, consider the impact of accommodating them, whether the site can be redesigned at an early stage with a limited impact. Number two, consider obtaining an insurance policy to cover the risk of an injunction and your legal costs potentially. This should be considered early, as an affirmative action will remove the ability to obtain a policy. So at the point that you have gone to the owners on the west side of Ilminster and said, we want to come to a deal with you, an insurer will then turn around and say, we can't insure on that basis. So consider insurance early. If insurance isn't available, or if it isn't commercially sensible because of the value of the premium, then consider a light obstruction notice. I mean, that again could be a topic all by itself. Certainly a good half an hour I could talk on that for. But in very brief, you register a hypothetical obstruction. So you formally register an obstruction, and if there is no objection raised on this, in this case by the owners of Ilminster Gardens on the west side for a year, then the time for a prescriptive right starts from scratch. So their 20 years would then start from scratch. Alternatively, you can just create the physical impediment, but that obviously requires you to build out height. Alternatively, as is always an option, if a neighbour does assert a right, you haven't got an insurance policy, etc., consider negotiation, consider getting out in front of it early. So the headline points are, I've said it a few times, get out in front of these issues early, identify where there are express rights of light, look for implied rights of light. And as I say, have a strategy. So yeah, that's rights of light. Back to you, Patrick, to introduce Rachel.
Thank you, David. So the third of our hot topics is telecoms. Doesn't come any hotter than this. There's a mast, as you can see, on the land. The obvious initial question often to us is this game over for the development, or is there anything we can do? Rachel.
Well, the short answer to that is no, not necessarily. But the slightly longer answer is no, so long as you know what you're going into well in advance. So the nature of the new code and the rights that that grants to operators and the ability for it to continue to burden land on which apparatus such as this mast is installed really means that you need to kind of look at this and be aware of what you're going into as soon as possible. The code is incredibly complicated, and we could do a whole series on the code and development projects, but for now I'll just go through a few top tips. So the first thing that a developer or interested developer will want to consider is whether there's any equipment on the land or neighbouring land. Sometimes, as is the case here, whether there's telecoms apparatus on the land will be obvious. For example, if there's a mast in the corner of a field. However, the new code protects all kinds of telecoms equipment, and so it would be important to investigate whether there's any cables, poles, communication boxes on, over, or under the land and neighbouring land. Obviously, this should be considered at an early stage by undertaking relevant searches, talking to those who know the history of the site, and the best possible thing is walking the area yourself. Where it appears as though there is telecoms apparatus on, over, or under the land, then the likelihood is that there will be a code agreement for that equipment, and at that stage, further investigations should be taken. Where no agreement can be found, for example, if it's a really historic agreement or the parties are no longer the relevant parties, then there is steps within the code which parties can take to find out whether apparatus is on land pursuant to a code right, at which point the new code will be in effect. So once we've bottomed out whether there is telecoms apparatus on the land and on what basis the apparatus has been installed, the next step is to take advice on the nature of that agreement to understand whether or how the apparatus will hinder any proposed development or dealings with the land in the future. At this point, it's really starting to get your ducks in a row to remove the apparatus if necessary, or to work out what you need to do in the future. So in many situations, existing apparatus on the land will not cause an issue to any proposed development. But because of the protections that are afforded by the code, it's important to understand the longer term position. For example, say you have a relatively small 3G mast on the property, which as it currently stands doesn't have an impact on the proposed development. The code provides operators with an automatic right to upgrade. So if the operator at some point in the future decides that they want to upgrade that mast to a larger 5G mast with a wider exclusion zone, is it possible that that upgraded apparatus might then impact the development or your plans with the property? If there's a chance that the upgraded mast might cause an issue later down the line, then you might want to consider any removal or lift and shift options available to you at this stage. If there is equipment on the land which will impact development or might impact development, and you wish to take steps to remove that equipment, then subject to meeting the test under the code for termination, you'll need to take steps to comply with both the contractual and statutory termination provisions. In principle, where a party does intend to develop the land on which there is apparatus and could not reasonably do that with the mast in situ, then there will be a ground for termination. But as with all things with the code, that's not necessarily quite as straightforward. And you'll want to consider with your advisors as to who the person is who actually intends to redevelop and who the relevant person is who should be seeking the termination. This will then affect how you terminate, whether you can terminate, and then take steps to remove the equipment. So even if you satisfy the test and termination is likely to be achieved, it should be understood that this can be a really, really lengthy process, and that will need to be factored into any kind of development plans. This will also depend on the engagement of operators, and it's really difficult to give a precise time that can take. For example, an operator might delay matters by serving a counter notice, and they might even enter into litigation proceedings to dispute the right to terminate in any event. If we're successful and the agreement is validly terminated, then you will then need to take further statutory steps to remove the apparatus from the land. So In reality, and from our experience, it really can take anywhere from 1 to 3 years to remove equipment from land and obtain true vacant possession. That being said, where a developer is likely to satisfy the termination and removal requirements, then what we often see is that operators are willing to engage to come to some kind of commercial arrangement which will minimise their network disruption and any unnecessary legal costs in dealing with the tribunal. This can provide a really good opportunity for developers to reach an agreement which might expedite the removal process, or at the very least provide some certainty as to when removal will take place, which can then impact the rest of the development. I think the key thing here is that the code is not straightforward and does provide a number of rights to code operators. It doesn't necessarily mean that any equipment on the land has to be fatal to the development, but it's really vital that is understood and acknowledged as soon as possible to put you in the best possible position going forwards in respect to the wider development process and plans. I'm going to hand back to Patrick now, who's going to discuss rights of way and adverse possession.
Thank you, Rachel. So as you can see from our mock-up, there are some footpaths running across the land. Yet again, we're dealing with the same prescription principles, i.e. the 20 years of use, etc., etc. So what happens here if the locals have been using these paths for more than 20 years? How do you manage this now, given the hopeful development? The two practical options for stopping time running are to strengthen the site's defences, so then you can show that access is with force, or by giving permission. Now, fencing is the ultimate solution, but yet again, we need to be wary of the TVG risk, because as soon as you put fencing up, you risk flushing out that TVG application. Furthermore, anything that stops the locals from using these footpaths could be an actionable claim, which again, like David's issues, could result in an interim injunction being granted. So in our scenario today, what we would do is as follows. We need to just tread very carefully around the rights of way. We would look to get the planning application in, so put a freeze on the TVG applications, then look to take steps to replace signs, maybe get a security team in place to monitor use, maybe think about giving permissions. Another option we've discussed with clients recently is rerouting the footpaths. That's an option. Also bear in mind not just the risk of private rights of way being claimed, but the public right of way test. And one way of defeating a public right of way is to make a deposit with the Commons Registration Authority to confirm that you, as landowner, do not intend to dedicate any part of the land as a PROW. But again, this can flush out claims, so it's just something to be careful of. The other issue I wanted to touch on briefly is adverse possession, another massive topic, something that you think of as squatters' rights, where, for example, one of the houses at Ilminster Gardens might look to extend their garden. I've seen this a great deal over the years. If Dillington Fields is registered, and for this scenario we say it is, then the starting point with registered land is that it is difficult for an owner of Ilminster Gardens in this scenario to claim adverse possession. They need to show uninterrupted factual possession for 10 years with an intention to possess the land. But the real kicker after the Land Registration Act 2002 is that you then, as an applicant, you also need to show that you fall within one of the three grounds, and the most common one is about establishing that you've made a reasonable mistake as to your boundary. And the reality is often they haven't made a reasonable mistake, they're just trying to get themselves an extra piece of land. So that's something to think about as well. So what would we do? Consult obviously with the landowners in question, perhaps talk about giving them a short-term license, giving them permission to use the land, but one that can be withdrawn when we say so. It gives you control and takes away that element of the use being without permission. Right, time has rattled on. We've got 5 minutes left and a couple of topics. Let's see where we get to. Rachel, obviously with land like this, you often have horses grazing, or it's being used for farming use. How do you deal with those sorts of agreements?
Yeah, so as you say, this is a really common issue with greenfield sites. And the first thing that you will want to do is there any evidence of farmers on the property? And if there are, the next questions you want to consider are, do they have exclusive possession? Is their occupation documented? How long have they been on the property? Have they been claiming BPS or any other further subsidies? Once you've got that information, then you'll have a bit more of an understanding as to how they're occupying that land and what you need to do to deal with that. Understanding that as early as possible is going to put you in the best possible position to be able to develop in the time that you want to and deal with things as early as possible, just so nothing crops up later down the line. So where a farmer occupies under the Agricultural Holdings Act, it can be far harder to regain possession, as the rights of the AHA tenants are heavily protected in terms of security of tenure and succession rights. So even where a landlord can satisfy ground to terminate, they will need to serve a notice to quit on the tenant, which could very feasibly require a 12-month notice period. The tenant farmer then has an opportunity to challenge that notice and raise an issue to the tribunal, which can cause serious delays or restrictions for any development projects. Where you have a farmer on the land pursuant to a farm business tenancy, an FBT, then the process should be more simple and, generally speaking, will require 12 months notice. However, that notice period could be greater where the farmer's occupation is not pursuant to a written agreement, and therefore there are questions as to when the farmer went into occupation. In that scenario, you could be looking at an increased notice period of 24 months. Finally, if there's a grazing license in respect to the property, the termination procedures should be set out in that license. Or where it's silent on termination, then the landowner will need to provide reasonable notice. Realistically, it's possible that you're looking up to 24 months to remove a farmer from the property. So as we say with all of these things, early due diligence as to the nature of the occupations is really, really important, and that will allow you to serve proper notice and get true vacant possession in due course. The other thing that's really important is that when you are taking an option or when you're dealing with options is to talk to the landowners as early as possible to make sure that they're taking steps if that is necessary so that you get vacant possession in due course. I'm going to pass over to David now, who's going to give a very brief overview of business tenancies.
Thanks, Rachel. Yeah, I really didn't think I thought we were going to run out of time and you were never going to get to me. So
you just got to do the whole of the 54 Act
in 45 seconds. Yeah, so I really will just give a whistle-stop tour, because this property, there is a business tenancy sitting on the top here. You'll see it in two kinds of issues. You'll see property in commercial units where there are business tenancies which are well established, and you'll see areas where there are licenses where there are questions over whether that license can be interpreted as a lease. The key issue is that there is a need to remove the existing tenant to facilitate the redevelopment. The question in this case is what grounds you can use to remove the tenant. The point is to get out there in front of it early. The key things to know once you're the owner or before you're the owner are: when is the period of the lease expiring, or is the business tenant in occupation and holding over? Are you intending to occupy for your own purposes? Certainly yes in this situation, but you do need to remember, it's very important to remember that there is a 5-year bar preventing you from objecting to a new lease. So you have to have owned the property for 5 years until you can object on the basis that you're going to occupy yourself. However, are you intending to redevelop the site? That's a ground under the 54 Act. In most examples such as this, you are going to be looking to redevelop. You're going to be looking to redevelop the commercial business offering into residential units. That requires redevelopment, and that would be satisfactory. However, you should get your ducks in a row as early as possible by pushing ahead with planning and ensuring that effective internal evidence is put in place, showing the intention to do the works. Remember that if the tenant can still occupy the unit after you've done your redevelopment works, there is a basis on which they can remain in occupation. Obviously, if you're converting a commercial unit into residential, that's not going to be an issue, but you need to be aware and get across it early. So sort of headline points: get your ducks in a row as soon as possible, serve an early notice under the 1954 Act, consider making the tenant an offer. You're going to have to pay them compensation anyway, so consider making them an offer that incorporates that to get rid of them and to have a clear route to VP. Also, if you're genuinely redeveloping the site, then dilapidations liability is likely to reduce to 0. That can actually be used as a negotiating tool with a tenant, because that could often be quite a big number. Engage early, look to come to an agreement with the tenant. That was about 45 seconds isn't it, on business tenancies.
Right, we've got to wrap up because it's 11:30, but thank you, David. But there's a lot here. We've tried to cover as much as we can in the bite size. We are going to do a follow-up note, which we will send round. We've also made a recording, should you wish to give this to friends, colleagues, family, anyone who would be interested in top video on demand. And don't forget, this is the first in a series. So our esteemed colleagues, Tim Ween and Becky Biscoe, are going to talk all things overage on the 22nd of March. So I please encourage you to sign up to that, and others will follow in due course. Thank you for joining. Have a lovely day.
Thanks, everyone.